Is your child's primary residential parent no longer fit to fulfill that role, and you're needing to pursue some kind of action in court to make yourself the child's primary residential parent? We get these calls fairly frequently, and people want to know, what are things that are enough to change custody? My name is Patrick Slaughter. I'm a lawyer with LaFevor and Slaughter, and to answer your question, the kind of modification you're seeking to file is a true custody modification. Not a calendar modification, but an actual custody modification. And the biggest difference is that now you're looking to switch the primary residential parent designation, which usually entails and must entail under Tennessee law that the primary residential parent is going to have the most time with their child during the calendar year. Well, it's a little more complicated than it used to be. Our Tennessee Court of Appeals used to say that there had to be a substantial risk of harm to the child in order to modify a plan of that type. They've since backed off that language, but they have still stuck to the premise that it needs to be something more significant than just a substantial material change in circumstances that would be sufficient to modify a calendar change for a parenting plan. What exactly is that? Common reasons for a primary residential parent or true custody modification include such things as a parent being arrested for some serious criminal offense and then subsequently convicted of that offense, or a parent developing serious substance abuse issues to the extent that it's no longer in the child's interest to be around that parent while they're suffering through that addiction. Other reasons could be child abuse. If the person who's the primary residential parent has neglected the child or abused the child in some fashion, that would be obviously a reason for a custody modification. So those are pretty straightforward and easy to find, but what are the more nuanced or difficult custody mods to prove? Well, there's a lot out there, and I wouldn't be limited strictly to things that appear to put the child at a risk of harm. One of the things that's happened fairly consistently over the past several years is our Court of Appeals has ruled that one parent being just overly difficult and refusing to cooperate with the other parent is enough to modify custody. So if your other parent is just refusing to co-parent with you, consistently won't turn over the child when they're supposed to turn over the child, refuses to give you information, consistently takes the child in violation of the parenting plan, that has been ruled as a sufficient reason for a true custody modification. It could be some other things. Perhaps the other primary parent's working situation is such that it leaves the child alone for significant periods of time, and that child may be taking care of themselves. For example, the child may be coming home from school and the parent's gone, and then they're at work or wherever they're at, and they don't come back until in the morning. So essentially the child's left alone. That can be a reason to modify. There's a few others out there, and again, you'd want to talk to an attorney. You have a situation, a particular fact pattern that you're living in your life, and you're very close to it. Sometimes it helps to speak with an attorney that does these kinds of things to get their opinion. There's a lot of us out there. If you'd like to talk to me, I'd be happy to discuss what your situation is and give you some ideas on whether that warrants a true custody modification. But if it is, it's a little bit harder to prove than just a calendar modification. So we better be prepared. You better make sure that you have your evidence lined up, and you better be ready to move forward and fight like the Dickens if necessary. Hope this helps. Again, if there's questions about that, you can leave some questions below, or if you'd like to pick up the phone and call me, I'm happy to talk to you about it. But again, putting your child first, you can't leave them with someone who's not fit to be their primary custodian.